When parents saw what their children were being taught during the COVID-19 school shutdowns, well, school choice became a topic of great interest. If government schools were going to substitute political theory for reading, writing, and arithmetic, parents wanted another choice. Now, most people can't afford private schools, and others cannot dedicate the time to homeschooling. Since people pay for these government schools through their taxes, shouldn't they be able to use that money for better options? Well, we'll discuss that next on the Constitution Study. Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach a rising generation to be free. I'm glad you could join me today. You know, there's a lot going on right now. I've got my tour getting prepared for. There's a lot of events coming up around Constitution Day and Constitution Week. I'll talk a bit more about that at the end of the episode. But for right now, let's take a look at this case out of Maine that involves school choice. As the most rural state in the Union, Maine is in a unique situation. Maine's Constitution provides that the state's legislature shall require the several towns to make suitable provisions at their own expense for the support and maintenance of public schools. In accordance with that command, the legislature has required that every school-aged child in Maine shall be provided an opportunity to receive the benefits of a free public education. While the Constitution of the state of Maine requires towns to provide for public schools, well, some districts do not have a secondary school. Maine enacted a program to allow parents in these districts to designate another secondary school for their children to attend, either in another district or a private school. And the state would send money to the school to help defray costs. Now, of course, with money comes strings, which two families got caught in. David and Amy Carson sought tuition assistance to send their daughter to Bangor Christian Academy, while Troy and Angela Nelson sent their son to Temple Academy but could not afford to also send their daughter. There was one problem for these two families, though. Since 1981, Maine has limited tuition assistance to non-sectarian schools. While both schools meet the state's requirements of being accredited by the New England Association of Schools and Colleges, the schools did not qualify as non-sectarian. Petitioners sued the commissioner of the Maine Department of Education, alleging that the non-sectarian requirement violated the Free Exercise Clause and the Establishment Clause of the First Amendment, as well as the Equal Protection Clause of the 14th Amendment. The district court rejected petitioners' constitutional claims and granted judgment for the commissioner. The First Circuit affirmed. Let's start with the complaint. As I've said more than a few times before, this cannot be a First Amendment issue because the law in question did not come from Congress. As the First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, this detail didn't seem to influence the Supreme Court's opinion, though. The Free Exercise Clause of the First Amendment protects against indirect coercion or penalties on the free exercise of religion, not just outright prohibitions. Now, it's worth noting that the court did not come to this opinion based on the language of the Constitution. Rather, they once again placed the opinions of previous courts above the supreme law of the land. While this requirement cannot violate the First Amendment to the Constitution of the United States, it does violate the Constitution of the state of Maine, which states, all individuals have a natural and unalienable right to worship Almighty God according to the dictates of their own conscience, and no person shall be hurt, molested, or restrained in that person's liberty or estate for worshiping God in the manner and season most agreeable to the dictates of that person's own conscience, nor for that person's religious professions or sentiments, provided that the person does not disturb the public peace nor obstruct others in their religious worship. As the suit alleges, Maine's policy also violates the 14th Amendment's Equal Protection Clause, which reads, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Does Maine's non-sectarian requirement violate the rights of citizens to equal protection of the law? Well, reading from the opinion, the First Circuit held that the non-sectarian requirement was constitutional because the benefit was properly viewed not as tuition payments to be used at approved private schools, but instead as funding for the rough equivalent of the public school education that Maine may permissibly require to be secular. Okay, the First Circuit Court of Appeals thought that requirement was constitutional because, in their minds, the money wasn't a tuition payment, but school funding. Meanwhile, I'm not sure what that has to do with the constitutionality of the requirement. Can the state of Maine create public schools that are required to be secular? Yes. The court noted, but the statute does not say anything like that. The benefit provided by statute is tuition at a public or private school selected by the parent, with no suggestion that the private school must somehow provide a public education. According to the First Circuit, it's okay to discriminate if the funding is for the equivalent of a public education, but not if it's for tuition. Thankfully, the majority of the court did not agree. Maine's non-sectarian requirement of its otherwise generally available tuition assistance payments violates the free exercise of the First Amendment, regardless of how the benefit and restrictions are described. The program operates to identify and exclude otherwise eligible schools on the basis of their religious exercise. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. Justice Breyer dissented with this opinion and was joined by Justices Kagan and Sotomayor. The First Amendment begins by forbidding the government from making any law respecting an establishment of religion. It next forbids them to make any law prohibiting the free exercise thereof. Now, as I've already shown, the First Amendment forbids Congress, not the government. That came from the Supreme Court, which makes the next quote even more disturbing. The court today pays almost no attention to the words in the first clause, while giving almost exclusive attention to the words in the second clause. Actually, the Supreme Court as a whole paid no attention to the words of the First Amendment, period. Like any good lawyer, Justice Breyer is good at playing with words to support his opinion. The majority also fails to recognize this play in the joints between the two clauses. That play gives states some degree of legislative leeway. It sometimes allows a state to further anti-establishment interests by withholding aid from religious institutions without violating the Constitution's protection for the free exercise of religion. The Constitution doesn't have any joints to play with. The First Amendment strictly prohibits Congress, not the states, from abridging the people's right to exercise their religion. What Justice Breyer refers to as anti-establishment interests seem more like anti-religious interests. Continuing from the dissent. In my view, Maine's non-sectarian requirement falls squarely within the scope of that constitutional leeway. I respectfully dissent. It should be no surprise that a justice of the Supreme Court placed their own preferences above the actual language of the law, and that is not the only place Justice Breyer got it wrong. Continuing from his dissent, we have never previously held what the court holds today, namely, that a state must, not may, use state funds to pay for religious education as part of a tuition program designed to ensure the provision of free statewide public school education. Now, as the majority pointed out, nothing in their opinion claims the state must fund religious education. The dissents are wrong to say that under our decision today, Maine must fund religious education. Maine chose to allow some parents to direct state tuition payments to private schools. That decision was not forced upon it. The state retains a number of options. It could expand the reach of its public school system, increase the availability of transportation, provide some combination of tutoring, remote learning, and partial attendance, or even operate boarding schools of its own. As I've already pointed out, the majority of the court sided with the parents. Yes, they claim that Maine's non-sectarian requirement violated the First Amendment. In particular, we have repeatedly held that a state violates the Free Exercise Clause when it excludes religious observers from otherwise available public benefits. However, since the First Amendment specifically prohibits Congress from passing laws abridging the free exercise of religion, it appears once again the court got to the right answer, but for the wrong reasons. What Maine's non-sectarian clause did by singling out religious schools for discrimination was violate the Equal Protection Clause of the 14th Amendment. So where does that leave this case? Maine may provide a strictly secular education in its public schools, but BCS and Temple Academy, like numerous other recipients of Maine's tuition assistance programs, are not public schools. In order to provide an education to children who live in certain parts of its far-flung state, Maine has decided not to operate schools of its own, but instead to offer tuition assistance that parents may direct to the public or private schools of their choice. Maine's administration of that benefit is subject to the free exercise principles governing any such public benefit program, including the prohibition on denying the benefit based on a recipient's religious exercise. While we should take the win, I think constitutionally minded Americans should also learn from the court's mistake. We may be happy with the outcome, but all it would take for the next group of parents to be discriminated against is a court with a couple of different justices on it. The Establishment Clause does not require a government to be hostile to religious observance or organizations. While there are plenty of government actors, including judges, who may disagree, the Establishment Clause does not require a secular government. It only prohibits a national church. Now, those who have stoked the fears of America becoming a theocracy have used the misinterpretation of Jefferson's separation of church and state to effectively do what they claim to be avoiding: establishing a national religion of secularism. This case is one small step for religious freedom in America. Hopefully, it will lead to a giant leap towards liberty for all. So this may be a small case, it may be a regional case, it may be a case that hasn't gotten a lot of attention, but there is some good news in there. Namely, that although they got there the wrong way, they did recognize that governments are not allowed to infringe on your right to religion. They can't discriminate against a school simply because it's religious. If you have a generally available program, it must be available to everyone, even those who are religious. So that's good news. I only wish the court would actually read the language of the Constitution and find it in its proper place. Because this idea that it's a First Amendment issue simply leaves us open to a lot of future government interference. I'll take the win, but I'm going to be a little conservative about the long-term outcome. Now, this is going to be a busy time here at the Constitution Study. Again, we have Constitution Day coming up in a few weeks. It's September 17th. And I've got a lot going on. I've got proclamations from the state of Tennessee. I've got an event I'm going to be doing with the 917 Society. I have a 2-week trip through the Northern Plains I'll be going on, bringing my Blessings of Liberty tour. And I've got other locations that are interested. I've heard people in Delaware, Pennsylvania, and West Virginia that are interested. People down in Tampa, people out in Texas. I'm still working out, trying to get schedules and dates. So if you're interested, please go to the webpage, constitutionstudy.com/tour. You can see where I'm already booked, and you can actually invite me to come speak at your event as well. And if you like this idea, well, you can donate to the cause and help defray my costs in gas money and lodging. I also have some other plans that I'll be doing with the website, but I'll have more of those in upcoming episodes. But for now, I hope you found this interesting. I hope you found other articles and videos and podcasts on the Constitution Study site interesting. Please share them. They are free for you to use. They are free for you to share to help others find the Constitution Study and the work that we're doing here. Now, if you're feeling alone, if you feel like the only person who really cares about the Constitution is you and your family, well, I invite you to check out Constitution Scholars. It is a place for scholars to meet. A scholar is a student. If you are a constitutional student or you want to become one, go to constitutionscholars.com. You can register absolutely free. You can gain access to not only other scholars, other people interested in studying, both around the nation and in your state. You'll get access to a library of resources, some online classes, and you can join our mentoring program where I can help train you to become a better scholar to the point where not only are you learning about the Constitution, but you can start teaching about the Constitution as well. All of that's there. Check it out at constitutionscholars.com. Hopefully you found this all helpful, useful, worthy of sharing with friends and family. Please do. Let other people know about the Constitution Study, and then bring them along. And join me here next time for the Constitution Study.